very good morning. We are respected dignitaries and resource persons on and off the dais, members of the registry led by Mr. Imsen, my dear judicial officers, members of the police of service, public prosecutors, ladies and gentlemen. At the outset, I must express my thanks and gratitude for having me given this privilege and opportunity to be here and to share some of my thoughts on the topic entrusted to me. It's really tricky topics of the Pocso Act, Section 29 and Section 30, dealing with the issue of presumptions. When this act came into force, at the very beginning, I can remember there was a deliberations in Guwahati, attended by a... half an hour, then interaction will go there. I was also not very convenient to see these provisions, because having considered the basic principles of administration of criminal justice prevalent in our country. Anyway, to understand the concept of presumption, because as you all know, presumption is also a rule of evidence and is associated with the burden of proof. So, burden of proof, all of you know that it is the principle or responsibility on whom the burden lies to prove a fact. Somebody comes to the court and desires that the court give a verdict in his favor. Law says it is his burden to prove. But the Evidence Act, this is the general burden on whom it lies to prove a fact. If we read Section 1 to Section 6 of the Evidence Act, Section 1 and 2 basically deals with the general burden of proof on whom the burden lies. Section 3 to 6 deals with certain specific cases, particular circumstances, which says that despite the principle of general burden, under certain circumstances, burden lies on certain specific persons. Now, if you read Section 101 of the Evidence Act, this is the first provision, which reads, because time is short, I will try to concentrate on the criminal side only, because Evidence Act is not only for the criminal law, it is for both civil and criminal, but I will skip the civil aspect of the matter. Whoever desire any court to give a judgment as to any legal right or liability dependent on the existence of facts, which he asserts must prove that those facts exist. When a person is bound to prove an existence of a fact, it is said that the burden of proof lies on him. Illustration, as all of you know, the illustration has the same force of the statute. A desires a court to give a judgment that B shall punish for a crime which A says B has committed. Now, A must prove that B has committed. There the must, the word is very important in criminal cases. So, if A says that B has committed a crime and desires the court should punish him, it is A's burden that he must prove before the court that it is A or B who has committed the crime. This is, we call in the common legal parlance, the initial burdens. This burden never shifts. Once it falls a person, it remains throughout the trial on that person's. You are also aware of a concept of onus, though there is a very fine distinction between onus and burden. Sometimes onus keeps on shifting. In civil law, it goes on shifting from this party to that party to this party. But in criminal law, rarely it shifts. Rarely. Then there is another provisions which is little bit, though it will not be proper to say exactly at exceptions, rather I can say it's an addition. 106 of the Evidence Act, which all of you are aware of, the judicial officers, that these provisions is intended that under certain circumstances, there is a change of onus. Now, even if in a criminal case, as I have read the first provision of 101, that the burden lies on the prosecution. Prosecution has to prove, prosecution must prove its case. But there may be certain circumstances where things may be such that which is exclusively within the special knowledge of the accused or the person who is being prosecuted. Then, in a circumstances, the onus shift to that accused to prove it. Now, superficially it appears that it contradicts with the basic principle of criminal justice, that the burden is only with the prosecution to prove. There are some other fundamental principles of the criminal justice I will deal little later. Now, I give an example. Suppose an incident happened within the four corners in the house at night. Nobody was there. Only the perpetrator, supposed perpetrator, I can't say perpetrator at this moment, or a man who has been accused of that commission of the offense, and the victim. If that fact is proved, and it is proved that he was there at the relevant time of commission of offense, and none else. So it is only he who knows. There is no others. So these provisions law cast a burden on him to explain. He can say, no, though I was there, I am not the perpetrator. So unless he explains how it happens, then he cannot take, in the circumstances, recourse to the principle of, the presumption of innocence. Because in that case, presumption of innocence, which is not only Indian criminal jurisprudence, it is an almost globally accepted, it is said to be human rights, a part of it, an important facets of the human rights, get limited. At some point of time, he may be deprived of that right to be presumed at innocence, unless he explain the circumstances. If he can explain the circumstances and can show that yes, he is not well, he can get the benefit. But in that circumstances, he cannot take recourse to the principle or the right of presumed innocence. You cannot. So this is called, otherwise called is a reverse burden. Burden get reversed to the accused. Though under the criminal law, burden, initial burden is always on the prosecutions. Now, there is a philosophy behind this. Why this burden is reversed to the accused? There are two aspects. One is social aspects, which is the primary, because society and the state, it is the responsibility of the state to protect the society, to protect the marginalized section, to protect the women, protect the children, protect. So in a circumstances, some protection is required. Because this is also, don't think, this does not violate the constitutional provision also, section 15, section 14, section 21. Because article 15, not section 15, article 15 itself, subsection 3 says that state can legislate, made some special law for the protection of child, protection of women, so and so forth. So though apparently it seems to be not in conformity with the general principle of criminal jurisprudence, appears to be there some discriminations, but it is within the permissible limit. Constitution allows this state to make the special law with the special provisions to serve the best interest of the society. So this is how this reverse burden or shifting of a burden under special circumstances is permissible. So before going to presumption, we must understand one more things. One aspect of the criminal law is on whom the burden lies, who has to prove it. The other aspect is how to prove a fact. What are the materials required to prove a fact? Judicial officer, all of you know, there are 6 things by which a fact may be proved before the court of law. Oral evidence, documentary evidence, material objects, admissions, judicial notice, and presumptions. These 6 tools before the court by which a facts can be proved before the court. Now, so presumption is also an efficacious tool for before the court to prove a fact. It is not always that the fact has to be proved positively either in existence and positively either in not existence. Presumption, all of you know, presumption is nothing but an inference, suppositions drawn from some facts which are proved or which are known. So one thing is clear, that there cannot be a presumption from a presumption. So in order to draw a presumption, there has to have some facts proved. There is no question of assumption. Those facts on the basis of which the presumption shall be drawn, or anyone can draw the presumption, any prudent man, that facts has to be there. If those facts are absent, if those facts are not proved, you cannot draw a presumption on air. So there has to be, you all know that there are some presumptions are mandatory, some presumptions are optional, some presumptions are given directly the status of evidence, conclusive presumptions. So presumption is also an important tool, I am stressing on it, to prove a fact. Now proving a fact before the court, not only to say positively that it does exist directly or that it does not exist, right? Now you have read this definition of proved. How a case is proved? The definition of proved, all of you have read it, I just for recollection. A fact is said to be proved when, after considering the materials before it, mind you, the court believes that it exists. This is direct. The court, after considering the materials before it, the court believes that it exists. Someone comes to the court and says that A has killed B, so court believes him, yes, matter ends, A kills B. Then, or that evidence may not be in all cases. Then what says? Or consider its existence so probable. See, though we say this beyond reasonable doubt, there is no scope for discussion on all these things because it will be lengthy. So, you see two concepts, belief, the court believes its existence, that it exists, or consider its existence so probable that a prudent man ought, you see, now you see, by the standard of a prudent man, not by a very high standard, not by a very low standard, ought, under the circumstances of a particular case, to act upon the supposition that it exists. So, the court suppose, court presumes, court infers on certain facts, though it is not directly proved that A has killed, but all the facts that has been proved, that indicates that in all probability A is the person who is doing the crime. So this is another aspect. So we should not be, in a area that beyond reasonable proof only refers to the belief of the court directly that it exists. It also refers to the supposition, and that too by the standard of a prudent man, not by the standard of Einstein, not by the standard of anybody else who have a very high, intellect, not even the low. So common. Therefore, when the matter is required to be proved before the court, particularly I am telling the judicial officers, so we must keep in mind, so it is the belief of the court, this is one thing. If the court believes that it exists, matter ends. If it is not in a position to that it believes that it exists, but he can suppose, he can presume that yes, in all probability it is so. So this is another way, this is how the presumption. So the presumption, though it is not a direct evidence, in all cases it may not be an evidence also, but at times it attains the status of an evidence and enables the court to decide a matter and they give the verdict, yes, it exists. Once the court comes to a finding, either directly it exists or on the suppositions on all materials that in all probability it exists, or fine, okay, fine, court can deliver the judgments. So this is how we have to understand what the presumption means and what is the, the evidentiary value of a presumption. Now, this sort of presumptions, not only in this Pocso Act, you find in many other acts. You find in the NDPS Act, Section 35, Section 54. You find in the Prevention of Corruption Act. You find in the Negotiable Instrument Act, so on and so forth. you find in the IPC 304B, you find in the Evidence Act 111 to 114, then there are other provisions also, 113A, 113B, and many other provisions. So this all deals with the provisions, presumptions. Only one thing, the basis of presumptions, what factors required to take the presumptions are explicitly deals in almost in all the states. If you see the Pocso, the NDPS Act, it says if the possession is proved, then there will be a presumption that his possession is illegal, he is possessing contraband, contrary to the law. So the illegality, contravention of the law shall be presumed. This is not in any other case, may not be. So NDPS Act itself says that in order to draw a presumption that he has committed the offense, if these two facts are proved, then there can be a presumption. Of course, there does not matter, does not ends, because all of you know that every presumption is rebuttable, be it mandatory presumptions, be it optional presumptions. Even the conclusive presumption also sometimes have got the windows for presumption. For example, I can say 112 of the Evidence Act. There is also a small window, though the definition of section, now it is section 2 under the Bharatiya Sakshya Adhiniyam, BSA, under the Evidence Act section 4, the definition says conclusive proof, no evidence, court would not allow evidence. Law says if A, B, C is there, D is proved. You are not allowed to adduce evidence. But in such case also, you read the section 12, you will find there is a window. Even that presumption is liable to be rebutted. So all presumptions are subject to rebutted, be it statutory presumption or legal presumption or mandatory presumption, whatever you say, or shall presume or may presume. Only difference is when it is may presume, court has the option. Court may presume, court may not presume. But when it is shall presume or mandatory sort of presumption, or we call it legal presumption, court is bound to presume. See, when that facts A and B is there, and it says the court shall presume, the court is bound to presume that yes, unless and until that presumption is rebutted. Because that option will always, accused will always have. Because that is in conformity with the right of the accused. He must have his say. He can rebut it. So, but if you read, the section 19, this provision is little bit vague. It says when a person is prosecuted. What do you mean by prosecuted? It does not say that if A fact is proved, B fact is proved, C fact shall be presumed, like NDPS Act, like the Prevention of Corruption Act, like 113B, like 304B. That says 304B, if the marriage is within 7 years, the occurrence is within 7 years, the torture, cruelty, demand, and all these things immediately before death, if these three facts are proved, then court can presume that it is a case of dowry death. The problem with section 29 is that it is not that explicitly says that on what basis the court will presume. It says that when a prosecuted. So what does the prosecution mean? Does it filing the FIR? Does it mean the filing the charge sheet? Does it mean filing the complaint only? No. But that has been discussed by the Supreme Court in many decisions. All of you must be knowing that Nuraga case, because though it has not been mentioned here what the prosecution means, prosecution does not mean mere filing the charge sheet or mere filing the complaint or mere lodging the FIR. Prosecution means those facts which are required primarily has to be proved. Here, while we understand or analyze the section 29 of the Pocso Act, we must be careful of some of the fundamental principles of criminal justice system. One, I have already said, that the right of the accused to be presumed innocence. Accused has a right to keep silent. He can say, I will not say anything, prove you, because it is your burden to prove. I have a right to remain silent. Yes, you have a right to remain silent. Burden is with the prosecutions. I have to be presumed to be innocent. But the special provisions when says that a presumption, when some facts are proved, that right to presume presumptions at one point of time come to an end, putting a corresponding burdens of the accused to explain those, to rebut that. Unless he can rebut, presumption will prevail. Then the court can pass a judgment even on the basis of presumption. At the beginning I have said that the presumption is an assumption, is an inference. You can ask how it can be accepted, because law says that the offense has to be proved by beyond all reasonable doubt by the prosecutions. So I have read the provision of the definition of proved. It has two parts. So under certain circumstances, the Pocso is one of the very vital act, special act, enacted for protection of the child, the women, child, because it's a gender neutral act. Pocso is a gender neutral act. It may be a male child or maybe a female child, it does not matter. And this act is also in conformity with the constitutional mandate. So nobody can challenge it. It was challenged that it violates the constitutional, right. But the court has said no, because it is at par with the, in consonance with the constitutional fervor. Now how you take the presumption? So the basic question is, when the presumption under section 29 operates, when court will presume it. There are one judgment of the Guwahati High Court, only one judgment I could lay my hand. There are laid down the principle, I will tell you, some of you may be knowing also, Bhupen Kolita or something. I will give you the citations. So even in the Pocso case, if you want to make a presumption, mere filing of complaint, all that, yes, I have filed the submission, prosecution is all that, I have prosecuted. Let the accused disprove it. No. Mere filing of charge sheet or complaint will not do. The initial burden has to be discharged by proving certain fundamental facts. Foundational facts, not fundamental, the appropriate will be foundational facts. If those foundational facts are proved, which does not prove the case beyond reasonable doubt, but only raises a presumption on the basis of preponderance of probability, in absence of any other evidence, court is 100% right to convict merely on such presumptions, unless it is rebutted. So we have to be careful only that one thing, section 29 or any other presumption for that matter does not absolve the prosecutions from its initial burden to prove the foundational facts. Suppose there may be situations, it may not be possible for the prosecutions to prove all things in a positive manner. But prosecution proves that a violence has been made on a child. A child may be a very 5 years, 4 years, 3 years, maybe he may not be in a position to talk even. There may not be even an evidence of the child. May not be. Does it mean only because the evidence is, child evidence is not there, the accused will scot free? No. So if it is proved by the prosecutions that violence was done, or the child is subjected to violence, it is of that nature, or some other facts which indicates that not must, maybe, accused may be associated, that is sufficient. If these fundamental facts are, foundational facts are proved, court is able to take a presumption. Therefore, section 29 only by way of reverse burden puts a corresponding burden of the accused once that presumption comes into operations by way of proving the foundational facts, then the burden shifts to the accused. Then the accused has to disprove it. If the accused fails to disprove it, on mere presumption, you can convict. That judgment cannot be challenged, that it is not beyond reasonable doubt. It is not necessary. Because this is a special legislation with a special object. It has been created to protect a marginalized section of the society. So court must be very sensitive while dealing with a Pocso case. You cannot be very mechanical. You must be sensitive. You have to scrutinize the evidence. Now, you see, section 29 is a rule of evidence. And the process of trial is a different thing. When you consider whether you will presume or you will not presume, it is only at the end of the trial. So by this time evidence is on record by the accused, by the defense. Then when you appreciate the evidence, then when you appreciate the evidence, when you weigh the evidence, and you find that the prosecution at least has proved the foundational facts, which suggest that A may be the perpetrator, though otherwise it has to be, must be, you know, there is a Supreme Court says there is a long distance between may and must. So convict a person, the prosecution must prove. So it could be proved that he must have committed. Here, you are allowed to convict only on maybe. You need not wait for must. But if the accused also adduce evidence, either by way of cross-examinations or by adducing his own evidence, dislodge, rebut, right, the evidence or materials sought to be produced by the prosecution, then section 29 vanishes. And in that case, the prosecution has to prove it beyond reasonable doubt. So one thing is, it operates at the time of appreciation of evidence, because presumption is a process of analyzing the evidence. It is not that some evidence is there, then you presume, then you ask other party. It's not that, because it always comes at the end. So if the foundational facts, which goes to show by the standard of preponderance probability that A may be, the prosecutioner, the initial burden of the prosecution stands discharged. If the matter remains there, no further evidence, court can convict very well. But if the evidence is there, rebutting those facts, then also not that you will have to acquit. Then burden becomes, stringent for the prosecutions. Then they have to prove beyond doubt that yes, he has committed the crime. So these two aspects we have to understand. Sometimes what happens, you try a Pocso case and you find that a very important ingredients of the Pocso Act, the age, is not proved. Or it's a marginal, border state. Or by evidence it is proved that the victim is major. So you need not send back the case. But only thing is, so mind you, don't confuse this with section 42. Section 42 is something else. Section 42 talks about the alternative punishment, means sentence, conviction, then sentence. The two different stages. Once the conviction is there, then the question of sentence comes. Unless there is conviction, there is no question of sentence. So we want to convict. Suppose you find that this age of the victim is above 18 years, so it does not satisfy the most important ingredients of the act, the crime, any crime, not only the 3, 5, 7, 9, 11, all offences under the Pocso Act, because he is not a child, he has to be a child. All of you know that in that case, you can convict him under the IPC provisions also. Then, though you are trying a Pocso case, mind you, you cannot invoke section 29. As soon as the ingredients of childhood is gone, it appears to be a major, and you decide to convict him under any provisions of the IPC, then section 29, section 30 vanishes. It does not operate. Another questions I just want to deal with, because that is very often raised. Suppose you are trying the accused for any offense, 5, 7, 9, 11 and so on and so forth, and no charge is framed under the IPC. It may be difficult on your part to convict under the IPC sections, because the ingredients are different. Because one of the very vital ingredients under section 376 is the consent. If the sexual act happens with the consent, with two major, it's not an offense. It's not an offense. So consent being a very vital ingredients of the offense under 376, therefore it is advisable for the Pocso judges, at least in the cases where you have a doubt, suppose the 17 years, 16 years, so this type of cases, you always frame an additional charge under the IPC provisions. Then accused cannot raise the plea that I have not given the opportunity. If you do not frame that charge and straightway convict the person under section 376, he may challenge it and says that that charge was not framed and the ingredients of two charges are quite different and no presumption is permissible under that act, so the conviction itself is bad. So in marginal cases where there is doubt that the age may not be proved to be a child, it's my request to all the special judges, you always frame a charge under section 3 under the IPC. It is not necessary that you have to frame the charge at the beginning. Even at the end also, while hearing argument, you find that this is a case where the juvenility or childhood is not proved. You can frame a charge in that stage also and proceed. There is no bar about it. You give an opportunity. Yes, I have added a charge. All of you know the section 16 onwards. Now perhaps it is under the new law, maybe section 39 onwards. You can frame. So convictions and punishment are two different things. So please don't, misunderstand this conviction with the punishment that has been dealt with section 42. Section 42 deals with once the conviction is attained and the stage of punishment or sentence receives, the provision says you are to give the higher punishment when both the ingredients of the offense under which the accused has been convicted. There is also a contemporary offense under the IPC of common ingredients, same ingredients. Then you can punish him, sentence him under the IPC provisions if that punishment is higher. Otherwise, if the ingredients are not same, section 42 also does not apply. Section 42 also does not apply. Therefore, presumption under section 29, as I have already mentioned, just to recapitulate, it does not mean mere filing of charge sheet, or it does not absolve the prosecutions from proving the initial burden. It also does not, say that all the fundamental principle of criminal justice will not be there, but there will be only some restrictions. So, section 29 of the evidence is the Pocso Act does not absolve the prosecutions from its burden to prove, it only lessens its burden. Prosecution's burden is to some extent lessened in this case, that even they can prove to the extent of preponderance of probability, assumption, probable, highly probable, and there is no further evidence, you can go ahead with the convictions. But if that foundational facts are not there, mere the filing charge sheet and all these things, the presumption will not operate. You cannot take the presumption, because in the beginning I have said the presumption cannot be on presumptions. Presumption has to be on the basis of some proven facts, on the basis of some known facts. If those proven facts in the form of a foundational facts of a particular case is proved, then only the presumption will operate, otherwise not. Otherwise you will know the general principle. You have to prove beyond reasonable doubt, no doubt. So that is only, you say, in one word if I say, section 29 lessens the burden of the prosecution in a Pocso case to prove a case. And that has to be filled up by them. And in this section 29, the burden of the accused to rebut the presumption is not beyond reasonable doubt, unlike section 30. So here the standard of evidence that has to be proved by the prosecution is preponderance of probability. But section 30 talks about another presumptions. This talks about the mental state. It's the knowledge, intention, belief and all these things. Section 7 with the sexual intent. Section 11, right? So when the law says, if the touch, you have been hearing the bad touch, good touch. So if there is some behavioral aspects, if it is bad touch or it comes under any of the provisions, that act is proved, court will presume that it was with that intention. So that intention, say for example section 7, intention with the sexual intention. So that will be presumed, that need not be proved. Once the fact is proved that he has assaulted, he has touched, he has done something, that part, though it is an important ingredient that the intention has to be required, that intention shall be presumed by the court. And the burden is otherwise. Accused has to prove, yes, though I pat on his back, right? He says, no, I love him, I love her, I just pat on her back. So he has to prove it beyond reasonable doubt, not by preponderance of probability, mind you, that my patting on his back was not associated with any sexual intent. He has to prove. And that proof is not by preponderance of probability, which is in general cases, the burden or the defense, proof of defense is always preponderance. But here, though he can come with a defense that my intention was good, my intention was not that, he has to prove it beyond reasonable doubt that his intention was not that. That is the difference between the burden of defense in a criminal case in section 30 of the Pocso Act in other cases. Here he has to prove by a positive evidence, strong evidence, that he did not have the intention. Otherwise, court shall presume. So two things, keep in mind that presumption is also an efficacious tool before the court to prove a case. And for presumptions, be it Pocso, be it NDPS, be it Prevention of Corruption Act, some foundational fact, the basic burden of the prosecution has to be discharged. Unless it is discharged, presumption will not operate. Once that burden is discharged, to the extent the circumstances of the law requires, presumption will operate. Once presumption operates and it remains unrebutted, you can go ahead with the convictions on the basis of presumption alone. You need not prove beyond reasonable doubt. Only when the presumption is rebutted, then only go to that extent. So I will stop here because this is a very important topic. I want the floor to open. Any questions on this subject? Because already we are behind the schedule. Let us have 10-15. Let us 10-15 minutes. Yes. Any questions? I suppose there are many questions. Yes.
We are running shortage of time, so kindly, if you have any doubt or any query, Lordship is actually he is mastered of in these matters. Any caution? IUs, we have all the IUs are here from Nagaland, even the prosecutors especially, to save the time. We are running shortage of time. Yes. Microphone, please give her the mic. Puko, please give her the mic. Oh, why not you come this side, man?
I am Dimsnaro Jamir, Public Prosecutor Dimapur. Sir, I want to make just a clarification here, and I hope this clarification it would be beneficial for the police who are dealing in this kind of cases. Now, when I went through the charge sheet, excuse me, I have come across that the victim, during the investigation and as per the school records, certificates, it says that the victim is a minor. But again, in the course of investigation, the IO takes the victim for ossification test. And the ossification test report says the victim is aged between 17 and 19. Now, by that report, it is not conclusively proved that the victim is a minor. But again, the school records, birth certificate or the cumulative records says that at the time of the offense, at the relevant time, the victim happens to be a minor. Now, the investigation brings a contrasting evidence now. So in that case, what should we do? Thank you.
The age of the victim is a very important aspect and ingredients of the offense under the Pocso Act. So it is the duty of the Pocso special judge to decide that issue. Now, you may not be confined or wedded to the materials that has been proved before you, produced before you. There are ways and means, you know. The court can itself, 319 is there, 91 is there are many provisions. Even 165 of the Evidence Act is there for you, before you. If you find that some evidence is not before the court, court is not helpless, helpless, that will be at the mercy of God. You can bring those documents and evidence if necessary. You are not helpless. First. Second thing, because that you have to decide that. The age. And how the age will be decided? You know, Section 94 of the Juvenile Justice Act, provides the provision, and earlier Rule 12 is also there. So the same principle, just the chronologically first you go for this evidence. If it is not there, go for the second one. If it is not there, go for the third one, medical. In that way, you will have to prove. You cannot go of your own. You must follow that, the Section 94 of the JJB Act. Now, you may say, the Pocso, there is nothing. Section 34 is there. But the Supreme Court has already said, I'll give you this, Janal Singh's case in 2013, that the same provisions of the JJB Act shall apply in, deciding the age of the victim also under the Pocso Act. So it is the duty of the court to give a decision on that, because unless you can decide that matter, you can decide the case. So it is your burden, your responsibility. Even if the evidence is not there, you are not helpless. The provisions of CRPC and the present BNSS give you all these options. You can yourself bring those evidence on record and decide the matter as per Section 94 of the Juvenile Justice Act. Right? Am I clear? Yes.
I'll just add something more to this. Again, this is a police viewpoint, which is probably more of a common man's viewpoint, but I think request everybody to make a distinction between a fact and an opinion. If you can prove from the college or the school record that the person is a minor, going for an ossification test where it says a range of years between 15 to 20 is irrelevant, I think. You are able to prove that fact from other things.
Yes.
When you have to make a difference between a fact and an opinion. If a fact is proved, you don't need to go for an opinion as a conclusive or even a proof to buttress your views. Okay? The fact is proved from the school record that he is a minor, so why go for an opinion? No, accused is not going to ask for you, for this. And why do you, if you know that there is a victim, support the victim in that case? Okay? Please, request everybody, including my police officers, to be use a bit of common sense there. Why do you need an opinion if you know from the school records or from the parents or from, say, for 20 years he is 15 years, for 15 years this person is 15 years of age. Suddenly the doctor says he is between 15 years to 20 years. Do you go with the opinion of the doctor or go with the fact, which is 15 years? Okay, so use a bit of common sense, everybody. I am not trying to malign anyone, but just a lot of law is common sense.
No, Section 94 is very clear. Section 94 of the JJB is very clear, because first you have to see all those documents, right? If those documents are there, you are not supposed to go to the second and third. If it is not there, then you go to the second. If the second is not there, then go to the third, medical opinion, because it is opinion is the last. If the first one is there, most preferable evidence is there, just throw away this medical opinion. You did not go there, because you cannot look into that also. You are not supposed to look into.
Again, not to the judicial officers, my request to my police officers is, be sure if you have a fact which can be proven without a medical opinion, just go with the fact. Okay, you don't need to collect any other evidence which you think is scientific, but it is more unscientific than being scientific. Yeah, obviously. Don't, I mean, होता ही scientific जब वो ना लगे थे, तो factual is more important than science, na?
Yeah, but during the medical examination of the child, that also can substantiate, because the doctor's examination also may say that the victim is a child or the victim is an adult. That also can substantiate. True. And why go for ossification test? Because that is the last option only.
So for judicial officer's point of view, I am telling you, you have to go by section 94 and no other things. Section 94 of the JJB is very clear. And if you brought this book, no.
No, not yet. It's not available.
Oh, sorry. I asked yesterday. Anyway, read section 94 of the new Act, 20 Act. You have to go by section 94, not by your own, procedure. Not by the procedure of there is a system, I know in Assam also, the procedure of Dhubri, procedure of Guwahati. Don't go by the procedure of Dimapur procedure code or the Kohima procedure code. You go by the procedure law laid down by the parliament. Section 94 is the guiding principles. You go by section 94, you will not face that problem. Simple.
Sir, just a query. I think I'm loud enough.
Yes.
Can I, sir?
Yes.
I think I'm loud enough. I don't need a mic. I may have misunderstood it. I hope I have not misunderstood it. But what I've made to learn is, basing on presumption, unless proven otherwise, the court can convict the person of pet touch.
Pardon?
That is what I thought I understood. Basing on presumption, the court can convict the person, unless proven otherwise by that particular person.
Yes.
That is what I was made to understand. I don't know whether that is the...
That is, I was dealing with section 29. Section 30. Section 30 says when there is a question of mental state, intention, knowledge. Suppose in certain offences, the intention is there. He intentionally did it. Let me read section 7 of the Pocso Act. 7, 11, just see. Whoever with sexual intent, right? Whoever with sexual intent touches the vagina, penis, etc., 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 so it's constitute an offense. So mere touching will not constitute an offense. That touching has to be accompanied with the sexual intention. The law says the prosecution need not prove the intention. If the prosecution proves that he had touched so-and-so part, prosecution's burden is discharged. Then you have to prove that my intention was good. My intention was not bad. So if you cannot prove that, that intention parts get automatically proved. Court will presume that your intention was bad. So unless you prove it beyond reasonable doubt, the fact that you had a good intention, you did not have that intentions contemplated in the provisions, the court will punish him, because that intention part shall be presumed unless rebutted beyond reasonable doubt. Am I clear?
It is very clear.
Yes.
But the accused, there will be no witness. In most cases, probably, there will be no witnesses. It may be the boy and the girl, for example. and then the boy will be alone, no witnesses, he will try to justify that he had no bad intention. And he will
You
stick
see
by
that law says, here again departure. Usually defense burden is to prove with preponderance of probability, not the beyond reasonable doubt. But here the burden of the defense is to prove that defense with the evidence beyond reasonable doubt. If you cannot prove that your intention was not bad, you will be punished, simple. The law says, the court will presume that. It is your burden to, there is no question of, there is no in via media. Either you prove that you did not have intention or face the consequence, simple. If the touch is proved, the prosecution's duty is only to prove the touch. And it is bad, good intention, it is you to prove that it was not with that intention. If you fail to prove, you have to be punished. Because I have already mentioned, this is a special legislation with a special object to protect a marginalized section of the society. That you will have to keep in your mind. Okay.
Yeah, any more question? Any more question? Police? We have so many IUs, but no one is raising any question. Court may excuse you later on. So please take the opportunity. Doesn't matter, your questions will be listened for all of us. Yes, police officers, please kindly, if you have any doubt. And then the public prosecutor also. We have to extend our lunch period because we just had a heavy breakfast. So I'm sure none of you is hungry now. So that we can we wanted to give sufficient time to our next speaker. So kindly bear with us for that. We have to postpone 30 minutes for our lunch break. Lordship, I think that's all for now. Any caution? Any more caution on this Pocso section 29 and 30? Okay then, ma'am, you may proceed.
Thank you.
Thank you, Lordship.
Good afternoon. I always hate to be the speaker between an audience and their lunch. But unfortunately, I am in that position right now, so I shall continue. I'm going to be talking about the Pocso, and I think one of the questions will get answered in this. Can you tell me who is protected under the Pocso Act? Who is the Pocso Act for? Who is the Pocso Act for? Children? Any specifics about the children? Under 18 years of age, right? So we are saying that all children under the age of 18 years, and I want to move away from this concept of boys and girls, because as we know now, we have a lot of children who come up saying, I don't feel like a boy, I don't feel like a girl. And so we are talking of all children, irrespective of their gender or their sex. Why 18 years? 18 is a very difficult age to prove. Because as a doctor, I'm a gynecologist, as a doctor, there is no specific, at 12 years of age, there are certain bones in the wrist, certain bones in the knee, which calcify. If I take an X-ray, I can say this child is over 12. But 18, I can't tell that. So I will always say 17 to 19. Because I cannot with definite, if you bring me to court and you say, why did you say this person is over 18? I cannot say it. It's bad in law. But the JJ Act says that if a child is between 17 and 19, you always presume 17, not 19. Because by taking the lower age, you give the child much more support in the system. So, 17 to 19, it's 17. If you have paper, school certificates, you have birth certificates, fine. We all know those can be fudged, right? That is the issue, that if it's fudged, if it's not authenticated, you may worry about the age. Do not take the medical age. In fact, it's very clearly given by Supreme Court. Do not keep doing X-rays of children because it does not prove anything. I can't give you as a doctor, this is exactly over 18, 18 years, 6 months. I can't say that. I will tell you 17 and up till 19. And you will presume 17 Because both under the JJB, if the child is an accused or child in conflict with law, or the child is a victim, in both cases, the law is kinder to this person. So why was 18 chosen anyway? Who decided this age, 18? Anybody? The UN Convention for the Rights of Children in 1989 brought in 18. It is an arbitrary age. The reason they brought in 18 is because there were a large number of child soldiers, both in Africa, in other parts of the country, who were being used at 14, 15, 16, 17. And so they used 18 at the maximum level they could push it. Because if you look in the US, for example, they allow children to drive at 16. And there are so many other countries where they allow them to carry arms at 16, 17. So they said 18 so that the child cannot carry arms till the age of 18. And so because India ratified this in 1992, we have had to take in 18, which is a completely arbitrary number and does not have anything to do with either ossification tests, maturity of the body, or maturity of the mind. A child matures at 22 to 24 years of age, not 18. And so we will take the younger age. So if you look at how the child rights paradigm works out, in child rights, there are 4 aspects that we always look at. The first thing is the right to survival. The second is the right to development. So in survival, hurting a child, beating a child, not giving a child food. Right to development is education, nourishing food, a caring atmosphere. The right to protection, under which Pocso comes in. So each child has the right to be protected. And that is why the presumption of guilt comes in, because if you have, as you also said, sir, if a child accuses an adult, and sexual abuse is always a private crime, it is a secret crime. Nobody is sexually abusing a child in front of others. It is done in private. So the only word is the word of the child against the adult. And the child does not have either the mental capacity or the emotional ability to speak out and give clarity. And which is why Pocso also had the idea that you have to give the special court has to give their answer within 1 year, and then they give a loophole saying as far as possible. So everybody chases the as far as possible. But it is infinitely better than 376, 375, which I have come in when we were doing cases in 2000 and earlier, which have gone on for 10, 12 years. And as we know, that the accused uses the ability to constantly adjourn and adjourn and adjourn and delay the proceedings till the child is so old that they don't want to come to court anymore. And finally, the right to participation. And this is lost. This is completely lost in our entire treatment of children because we do not let them participate. So what are the special features of the Pocso Act? Can anyone tell me how is Pocso Act different from 375, 376, 377? Anybody? Child is mentioned, yes, very clearly, child under 18. Yes. Very good. Anything else? Anything else? Because 375, 376, 377 was anybody. Could be an adult, could be a child, the age was not important, right? So what is important in Pocso? What comes in here? For the first time, they shifted away from the perpetrator being male. 375, 376, 377 is peno-vaginal, peno-anal. The penis is the perpetrator. But we do know that women are perpetrators too. We know that boys can be victims too, whereas in these cases, other than 377, 376, 375 always talked of women as laborers. So the first thing in Pocso which came in was it is gender neutral. The perpetrator can be any gender, that is male, female, trans, and the child can be male, female, trans. And why I'm mentioning trans very, very importantly is you will find that specifically among boys more than among girls, when a boy is not sure of their gender, and all of us know somebody among our family or on our outer circle, a boy who is a little different. And as they grow, they may ultimately end up saying, I'm trans. I actually feel like a girl. I don't feel like a boy. Now this sexual confusion which arises in some children because of gender confusion makes them more likely to get abused because they're confused about who they are. And perpetrators are psychologists. And with all due respect to any psychologists over here, a perpetrator is a very smart psychologist who watches children and traps them. Very rarely will you get a chance abuse. You know, in a market, I had one girl who came and told me she was on a school visit. They were all, school trip was going in the train. And then, you know, in the night, just before they went to bed, she came and she was waiting. You know how you wait and that the bathroom is shut, somebody is there, so you're standing in the corridor waiting for the bathroom to be empty so you can go in. And this man walked past and squeezed her breasts very hard and ran off. She just froze and then she came running back to her coupe and she started crying bitterly. Her friends asked her what happened and she told them. And then she said, don't tell the teachers. I had gone to their school to take classes on sexuality education and the girls, 2 students came up and told me, ma'am, can you please call our friend? She has become very depressed since that happened, but she has not told anybody. Not her family, not the teachers, and we are really worried about her. So that is accidental. But most of the time, and we'll discuss some cases, it is completely planned. The next thing about Pocso is the mandatory reporting, which we will also discuss because no other ones. And mandatory reporting unfortunately has come in because we, both as doctors, police, and society at large, did not protect children when they were abused. Oh, my daughter's getting abused by my brother-in-law, but he's a very important part. Our family name will get spoiled, right? So I'll tell my daughter, shut up. You know, you stay next to me. Don't worry. Or a teacher or a principal or a respected member of community has been abusing children and everybody goes, well, he's a very important person in our community, no? So, you know, we should not do anything because, you know, the name of our community will get spoiled. And so, therefore, mandatory reporting came in to punish us because now we are really stuck with this. As a doctor, it's a big headache for me. But I deserve it because I did not take care for children when they came. The other thing is in the Pocso Act is there are different degrees of sexual violence. Earlier it was only penoanal, penovaginal. Anything else for male to female was 354, which was outraging modesty. There was nothing in between. And we all know that there are many, many levels of sexual assault. So if you look over here, there is penetrative. And even in penetrative, they talk of many levels. Penetrating with a finger, because there was this case of this man who was using a pencil to put it into children's vaginas. And he said, there's no penal penetration, and so he got off. Any object put inside an orifice of a child with sexual intent is considered penetrative sexual assault. There is then non-penetrative, which would be touching, pressing of the breast, touching of the penis, touching of the genitals, kissing the body, anything of that sort. Then comes non-contact. Photographing children when they're nude, standing at a swimming pool, watching the children going in, watching children bathing, putting a camera in a bathroom. All these things are non-contact. And making children watch pornography. There was one principal in Bangalore, I am from Bangalore. There was one principal in Bangalore who used to call students in who were punished, who had been caught for not doing homework, particularly boys of class 9, 10, and he would show them pornography on his laptop. And he must have been doing this for months on end till one student went back and told his parents, principal's showing some dirty pictures, I don't know what to do. It's very scary. And that's when the case started. Pornography, using children in pornography, taking photographs, and I think one of the things which is very, very important to understand is a person who abuses children very often has child abuse photographs, child pornography photographs on their devices. So rule number 1 is when you have an accused, please take the mobile phone, laptop, iTab, any of it, confiscate it and assess it because you can put them in behind bars on just having child pornography. Adult pornography, it's a wish. People want to watch it, that's your choice. Most adult pornography is by paid actors. there is no payment for child pornography. And child pornography in your device is a crime. Then we also have different levels, aggravated and non-aggravated, and that's really important because we are saying that anybody in an institution, armed forces, police, doctors, principal, institution, relative, anybody who is meant to be protecting the child, they will come under aggravated. If the child is below 12, if the child has gone into mental health issues, if the child has become pregnant, if the child has connected HIV, if the child is depressed, if the child has self-harm. There was this girl who came to me, she was 16 years old, and when I was talking to her, I saw her arm, and she had cuts, old cuts all down her arm. And we know that if the cuts are only on one arm, she is a right-handed person, she sits and cuts herself. And I asked her, I said, you've been cutting yourself? And she said, yes. And I said, why? And she said, sometimes she had been raped by her stepfather for about 3-4 years. When she started her period, he started using condoms. And he kept pulling her away from her mother so that she distrusted her mother and she could not even report to her mother. She reported actually to a teacher who told us. She said that after so many years, I'm not even sure that I'm alive. And sometimes I feel I'm dead because I don't feel anything. And so when I cut myself, it pains. Or when I cut myself, little blood comes out and I realize I am alive. I'm not dead. And when this 16-year-old girl was talking to me, my heart just shrank that this is what this child was going through. So, aggravated and non-aggravated. Then abetment comes in because earlier there was a principal who used to abuse these children. That principal is still the principal in a school because he has escaped, he has high contacts and he has managed to come back to schools in a different area. The teachers used to send him children. Those teachers are abettors. And finally, attempt to commit. So all these things have come into Pocso Act, which we can use effectively to prevent people from escaping their abuse of children. Let's look at the factors in child abuse, because this is what is very important. You know, when we are talking of presumption of guilt and presumption of innocence, now as a public prosecutor, as an investigation officer, you are trying to create a case. What are the things you're going to look at to tell you that this child is at risk? The first thing is the socio-cultural milieu. So if there is a very close-knit community, if the person is of a very high standing in that, it's going to be very difficult. If it is a family member, it becomes extremely difficult for people to speak against it. One of the things in the socio-cultural milieu is our acceptance of hitting children. How many of you as children were hit by your parents? I was. My mother would slap me and my sister when we fought. Anybody else? None of you were hit by your parents? I am so impressed. Nagaland is wonderful. Please put up your hands if either of your parents ever slapped you or hit you for some mischief. Oh, okay, Nagaland's like my hometown, okay. All right. This, when you first hit children, you break a boundary. We were talking about parents teaching children boundaries. You have taught your child unsafe touch. You have taught your child bad touch. What do I mean by that? I take a glass as a child and I dropped it, it broke. My mother kept saying, keep the glass inside. And I don't want to listen to my mother, she's so boring. And I kept it broke. So my mother slapped me. My grandfather kept a glass over there in the same place. And my mother said, just put it in a little closer. And he also doesn't listen to my mom. Nobody listens to my mom. And the glass broke. But you know, she didn't slap him. She said, it's okay, don't worry, I'll clean it up, it's fine. And so I learned that when people are powerful and they hurt you, you can't fight back. So tomorrow when my principal abuses me, or my boyfriend abuses me, I have already learned in my house that older people, more powerful people have the right to hurt you. And so one of the things we talk in schools, we talk to parents is don't hit your children. And I don't think, how many of you hit your children? Or how many of you have brought up children without ever hitting them? Yes, no? So tough, right? We are so used to it that our hands will raise, and it's not okay. You cannot hit a child. So the socio-cultural milieu that we have, the social stigmatization that many of the speakers earlier were talking about, keeps to that place, okay? In the community, of course, the question of who says what, how do they see it, is the exploitation. The other thing which comes in is internet over here. Why is the internet, this is the new internet generation, you cannot stop them from accessing internet. But parents, teachers have to keep speaking to children of what the internet shows, because the internet is extremely misogynist. It is misogynist and it causes harm both to women and to children. And so the parents have to keep breaking the internet down for kids. And the sexualization of young children, why is it that we get 10-year-olds trying to have sex with their classmates? Why do we have 13, 14-year-old boys raping an 8-year-old girl? They've seen it on the internet. And they think, maybe I can do something about this. And I do want to mention, Pocso cases are more now because we report it more. I know people who are 60, 70-year-olds who've told me that they were sexually abused as children. So it's not that it didn't happen earlier, but the sort of stimulation that the children are getting now increases sexualization, makes them feel like having sexual urges where they don't even understand what a sexual urge is. Finally, in family relationships, what we have found is in broken families, where the parents have, one of the parents has died, the parents are separated. If the children are exposed to intimate partner violence, if there's domestic violence in the house, so your domestic violence and alcohol abuse also feeds into child abuse. And finally, in the child, if the child is unwanted, one of the things we keep saying is parents don't have time for the children. When you ask the parents, did you really want to have the child? I'm a gynecologist. I ask them, did you want to have this child? They go, accident. I'm like, wow, an entire human being arose because you had an accident? But the child is an accident. And so the parents are not committed to that child. They didn't want to have the child. So where is your commitment to the child when it was something you didn't want? And there, MTP helps. The reason in a lot of European cities, sexual abuse has reduced was because unwanted pregnancy is reduced. A woman has 8, 9, 10 children. She doesn't want the children, but she doesn't know. She's not been taught contraception. She's not allowed by her family to go for contraception. She has children. She has no mental capacity to take care of, and the father. So let's go to a story, and we will discuss how do we follow this pathway. So Lily is 3.5 years old. She stays in a small hutment colony near a construction site. Her parents are daily wage laborers. After dinner, she went out to the toilet behind their hut. Her mother was busy cleaning dishes, did not realize till an hour later that Lily had not returned. She and her husband immediately went out to search for her and found her lying semi-conscious on the ground. Her underwear was thrown to one side and she had blood over her genitals. They rushed with Lily to the health center. Okay. Now, where will this child meet the system? So what we're going to look at is, how do children come into the system? Where will this child go now? Where's this child going? Where's the child gone? Yes, thank you. So, how children, when they're abused, where do they first start fitting into the criminal justice system? Very often, they will go and talk to family members, and the parents will hear and they'll call the family members together and say, see what happened, what do I do? Or they may go to the village council and say, this is what happened to my daughter, this is what happened to my son, what do I do? They may go to the government healthcare center like this Lily has come, or they may go to a private doctor. They will not come right now to a psychologist, to the police station, or to a private lawyer. That will happen. If the child is in school and has been molested in school, the parents find out, they may go to a lawyer first, or they may go to a police station, or the school headmaster. So here they've gone to the private doctor. Now when this child comes into the system of having met a government doctor, how does the doctor proceed? Anybody? What should the doctor do? Anybody? Yes? Where are the doctors? Can I have the hands up and show of the doctors here? Don't be scared. I won't ask you to answer any questions. I was in medical college. I was terrified. I used to sit in the back bench exactly like the doctors here. Okay. Yes, doctors, what would you do if this child comes to you? It's just speak out, because if you really knew everything about Pocso, my coming here was a waste of time. I spent 9 hours in a car coming from Shillong to here. I reached at 9:30 at night. And I do it because I care. And so I'm going to ask you this question. What would you do for this girl?
Please don't waste your time.
Sorry?
Doctors.
Yes.
The Commissioner Secretary is here with us.
Oh, don't worry about that, okay? That's very scary. Don't say that. They'll get small scared, okay? See, the thing is, we don't know. I did my MBBS, I did my MD in gynecology, and I had no idea how to examine or write notes on a sexual assault victim. I had no idea. I think 20 years after finished gynae, when I got involved in cases of sexual abuse, is when I started reading up and getting trained, and that's when I learned. I had no idea. Okay? So what would you do? Anybody? Just take a guess. It's fine. It's okay to be wrong. You know that? It's all right.
Take care of the physical aspect of the child.
Yes, because the first thing is the child is your patient. As a doctor, therapy comes first. The medical legal system comes second. The child is coming semi-unconscious, the child is hurt, the child is bleeding. I need to take care of the child and I need to take care of the parents. One mother had come to me, her 6-year-old daughter was molested by the neighbor. She had 2 elder sons who were I think 13, 14, and this girl was born and she was 6. And when the child started going to full day school when she was 5 years old, the mother decided to work because the husband used to work as a welder, and both the parents wanted to give their children a good education, and that was not possible on one salary. So this lady started working. And of course, from her house, her mother-in-law and people said, you should look after your children. Why are you working? And she said, I come back by 4:35 when my daughter comes home. I'm there at home when the kids are there and I leave with them. But in this case, she got a little late because the bus was late and this child had been molested by the neighbor. So when they came into my OPD, the child sat down and I started asking her questions as to what happened. And when she started saying, he pulled down my pants and he put his finger in my vagina, and she said, he put my finger, he did dirty things. You know how they talk? They'll say they did a dirty thing. The mother started bursting into tears and started crying. And the child got very scared and she looked at the mother because the mother started sobbing. And I said, your mother's not crying because you did something wrong. Your mother's crying because you got hurt. It's okay. Because children don't want to upset their parents. And a lot of the times, sexual abuse is not reported because the child thinks, if I tell my mother that her brother is doing this to me, or if I tell my father that his friend who he trusts totally and absolutely is doing this to me, my parents will be shattered. And they will be upset. And so they don't tell. So it's very important when a child of sexual assault comes in that you reassure the parents that they're fine. One of the typical things we talk about is parents don't care about their children. I don't think so. They do. But a lot of the time, they don't have the mind space to do it because they're busy with work and adults and other sort of things that they have to do. So please give respect to the parents and understand their trauma, because for a parent to know that my child was abused and I did not protect my child is devastating. So, the point is, this is the standard way we look at sexual abuse cases. You have to report it. You have to interview the child. You have to file an FIR, so you have to send the knowledge to the police station. You have to do a medical examination. You have to do any medical procedure if needed. For in this case of this child, you have to clean the injuries and wipe them up. Then there is the arrest or remand of the accused, which will occur on the FIR. A support person is to be assigned. Do you have support persons for your cases? Do you have? How many support persons do you have in Nagaland? I believe the Department of Social Welfare is not there. Where do the support persons come from? Anybody? Where do the support persons come from? Do you have support persons designated? Child Protect, no, not the Child Protection Unit. So the Child DCPU, the District Child Protection Unit, are the unit of a psychologist, social worker who will work with the child. But either the NGO or someone is designated a support person. They have to give in their, a form to CWC, and then only they can be support person. A support person has to be designated. Because the support person, so in Bangalore with the organization I work with called ENFOLD, we have support persons who are designated by CWC, so each case has a support person. And the support person gets called at 12 at night from the mother saying, I want to commit suicide because today I got these people came and they started harassing me and shouting at me and saying, take back the case. And the support person calls the police station and says, can you please go there because the person is out on bail. The support person is the one who helps them get their compensation. The support person is the one who gives them emotional safety, gives them emotional support. A support person is very important. If you're working on a case, find out where's your support person, who's the support person. You need to have that. And then the investigation proceeds. So the investigation will be in terms of evidence. Now let's look at the filing of the charge sheet. Now in this case, you're not doing the reporting, you're not doing an interview, you're not filing an FIR, you are only looking at medical examination and medical procedure. Because this is an emergency case, this is for the doctors, right? So in the beginning, all you're doing is taking care of this child. Arrest, investigation, filing of charge sheet, everything is afterwards. So in this case, when a child comes hurt, you first take care of the child. Now it is very important to collect evidence at the same time also. And here I want to tell you of a case in Orissa which had occurred, where this child went out in the night to the toilet and didn't come back. So in the morning, so the mother didn't know when the child went out, around 5 in the morning when the mother went to the bathroom, she saw the child frothing at the mouth, lying just outside the toilet. And so they realized that the child had been bitten by a snake. So they immediately picked up the child, went to the closest primary health center, where they checked that the child was still unconscious, and they transferred the child to the district hospital. In the district hospital, because the doctors were smart, they started putting the IV line, they started taking care of the kid, and when they put the catheter in to check, they found that the vagina was torn, and that's when they realized this was not snake bite, it was sexual assault. So any case of an unconscious child coming to you, please have a high index of suspicion. Do the complete examination. Don't believe that the child fell off the balcony, the child fell off here, the child fell into a pond. Don't believe that. Examine the whole child. So in this case, the examination will start, and I'm going to talk to you about what is the examination that you're going to do. So in this case, first, best interest of the child is always your principle of management. You have to be competent, you have to care, and you have to be committed to the well-being of the child. So I'm just going to quickly go through what is the medical examination that you will do. In this case, you would have started IV lines, you have examined the child, check for injuries. How do we examine a child? So we have something called the medical kit. I have brought it over here because it's one of the simplest things. There is no such thing as a forensic sexual assault forensic evidence kit. It is not necessary. All of you can have all this material in your casualty. Just like if a person comes in with an injury which requires suturing, you have a suturing trolley, right? So you have different needles, you have different suturing material, you have anesthesia, injections, all these things, scissors. The same way, you have a trolley. Now, in the trolley, what is going to happen is, first is consent, then you give first aid, then you do the examination, and then you do the evidence collection. So, these are the simple things that you will need. You need gloves, you need a comb, you need scissors, you need a nail cutter, you need forceps to pick up any evidence on the child, you need a measuring tape to measure any injuries, always document everything. Then you have blotting paper. In the blotting paper, you will take, suppose you find that there is some sort of discharge near the vagina. It could be semen, it could be something else. If she says that that man bit my breasts and he licked my breasts, you can take the saliva from there. You will put it onto the blotting paper. Otherwise, you have swab sticks which are sterile. You will open the swab stick and you will take the tissue. If it has occurred long time ago, you will use distilled water. You will use distilled water, put a few drops on the swab, collect it and then dry it. Don't put wet swabs into a container, because by the time they go to FSL, they will have fungus and FSL will come back with negative. You have to air dry it. Then you have a syringe for collecting blood, and you have an EDTA bulb. This is for DNA analysis. You have plain bulb for blood group and drug estimation, and you have sodium fluoride for alcohol. So depending on the history given, you will take one of these. These you should have. This is there in all hospitals. Swabs are there, blotting paper, and you will have a small bottle for urine pregnancy test. You have glass slides. Once you take a swab, you can put it onto the glass slide, let it dry, put a cover slip, and that is part of your evidence. You have a urine pregnancy test to check. This is how you will manage. Each of these will be dried and put into a separate envelope, which will be labeled. And finally, you will put it all in a bigger envelope, which will be sealed with lac and sent with the police, whoever has brought the child. If it is an adult or someone older, adult meaning older minor, you have a piece of white paper which will put on the ground where she will remove the clothes, provided this is the clothes the child was wearing when they were assaulted. FSL has a huge go down full of clothes, because every time the child comes, you take all the clothes and give it. The child wore the clothes 1 week ago. Please don't do that. Within 96 hours, if the assault occurred, you will take swabs and you will take examination material. And if the same clothes were on the person when they were assaulted, you will ask them to stand on this paper so that they remove their clothes. The clothes will be air dried, but there will debris which will fall on this paper, which will be folded up and sent to FSL. The debris over there, she says, I was assaulted in a park. And the accused said, I was never in the park. I was staying, my friends have come to tell me I was sitting with them and we were drinking and playing cards. But on this paper, there is grass and there is mud from the place where she said she was assaulted. It is circumstantial evidence. So this sort of evidence is useful to be taken. So this is the way you continue the whole thing. In terms of how we examine a child, now this is a 3.5-year-old child. This child was semi-conscious. She will be scared. She may be, if she is semi-conscious and not aware, she can lie down on the bed and you can examine her completely. And you will take the swabs from the vagina, from the thighs, you will take blood samples, everything else you can take. But if she is older, 2.5, 3, who said, my teacher did this, or the van driver did that, or my cousin did this, the child is not going to lie down on a bed. So what we do is ask the mother or whoever's come with the child to sit at the edge of the table and hold the child. You know how when you take your children for a ear infection and the doctor has to look in the ear and the child is not going to sit quietly. You hold the child like this on your lap and you just hold the head so the doctor can look into the eyes or the ears. So the same way, you make the child sit on the mother's lap, ask the mother to remove the clothes. Don't ask your nurses to remove the clothes. It's panicky. So you ask the mother to remove the top and you examine the whole child top to bottom. Don't look at the genitals alone. See the whole child. The child is used to a doctor looking into their eyes with a torch. So start from there. Talk to the child and say, somebody hurt you. I understand that. I'm just going to do a checkup for you, And if there's anything which is hurting, I'm going to give you some medicine which will make you feel good. One of the things I always tell children is, I'm not an injection doctor. Because the only thing they know is, if you don't eat, I'll take you to the doctor for an injection. So I'm like, I'm not an injection doctor. I'm just there to see how you got hurt, and I will give you some medicine to make you feel better. And your mother, you can sit on your mother's lap, or if you're a big girl or a big boy and you're not a little brave, you can lie down on the table, and your mother or your father will hold your hand, and I will examine you. they will take off your clothes. So you tell them to take off the top part and you put a sheet over the child. How would you feel being naked on a bed? Uncomfortable. So you use a covering sheet and see the top part of the child. Then you shift the sheet to the upper part of the body and ask the parent to remove the pants and examine the child completely. The courtesy you give to the child is actually making the child feel more comfortable and trusting you. So this is how you will do it. Now let's look at the second story. Any questions so far? Any doubts? Any questions? Okay. So everything over here is something which is available in every casualty. There is nothing which is rocket science. The only thing which is not here is an FDA card for the DNA. So if you need that for any reason, like you have taken a swab of blood from the genitals and the blood is not the child's, it may be another person's, then you would have to do a DNA testing. You can do that later. Now let's look at a second story. So in that case with Lily, what happened was the examination was done, the child was stabilized, all the evidence was collected, it was sealed and given over to the BO. The medical report was given immediately. The medical report is on this. Ministry of Health and Family Welfare Guidelines has this 11-page document. When we all look at it, doctors hate documents. I'm sure police also hate it, but you just have a lot in your lives. Judges and prosecutors love documents. The more the document, the better. 5,000 pages really works for everybody. But doctors hate documents. But if you practice this 3-4 times, you can do it in 10 minutes flat. It has every question, starting from consent, what exactly happened, the narrative, were you given alcohol, were you given anything to drink, where did it happen, how many times, particularly for a small child. If a sexual assault has occurred many, many times, we don't say, what happened? Because the child cannot remember, 6, 7, 8-year-old child. So you say the first time it happened, what happened, where did it happen, get a detail. The last time it happened, where did it happen, how did it happen, because it's easier for a child to remember that. And the last time when you ask that, it becomes easy because you know, is it more than 96 hours, should I collect specimens or not? Please don't collect specimens to send it for FSL, which will give you the reports after 6 months, delaying the charge sheet, during which time the accused has got bail. So, as doctors, please take evidence carefully. There was this boy who had come to me once, and he said that he was playing with his ball, and he went, and the ball went into the neighbor's house. So he went inside, and it was a PG for men. And the one young man said, "What are you doing over here?" He said, "No, my ball is coming here." He said, "Oh, yeah, your ball is here." And he took the boy inside. He pulled down his pants, and he pushed his penis into the mouth of the child. The child tried to struggle, so he held his hair really tight. And then finally, the child managed to push himself away and ran out. The child came home and just sat down quietly in one corner of the house. And the mother said, "What happened? You finished playing?" He said, "Yes." Then she put out dinner and she called him, and he was very quiet. And he came and he sat down and he put food in his mouth and he vomited. So she said, "What happened?" He says, my throat is paining. So she said, "Okay, then you have some curd rice." So he had a bite of that and he vomited again. Then he started crying. So the father said, "Oh, I think he must be getting fever, let him sleep." So he slept. In the morning he got up, she gave him milk, he vomited again. She gave him breakfast, he vomited again, so they went to the hospital. In the doctor said, "What happened is he's vomiting." So the doctor gave some anti-vomiting medicine and sent them back. The child came home, they gave the anti-vomiting medicine, the child vomited again. Finally the child was crying, fell asleep. Then in the evening the child got up again, they tried to feed the kid and the kid was vomiting, and the mother said, "No, we have to go back." They went to the doctor and the doctor said, "Oh, he's not had any food since yesterday, we'll have to put an IV line." The moment the child saw the injection, he started crying and said, "Actually, I don't want an injection, this is what happened to me." So the mother came to me for the medical examination. They went to the police and the police brought them for the medical examination. I got the history from the mother and I got the history from the boy. He was 7 years old and extremely articulate. So in this case, because it was oral sexual assault, what I did, first of all, I wrote in my findings, child has vomited many times, washed his mouth, eaten food. So if there is no evidence, there is a reason why. Tomorrow when the FSL comes back and says nothing was found, so I took the swabs and I took the buccal thing. So in oral, we normally take it and we take behind the last tooth because that's where the fluid collects. If there's any seminal fluid or there anything, it will collect in the back of the mouth. So you collect it from there. Plus, if there was sexually transmitted disease, that you would collect on this. So for sexually transmitted disease, I took a gram stain and I took a swab, but I also wrote that the child has vomited many, many times, washed his mouth out many, many times, because the poor kid was feeling so dirty about it. And therefore, there was a very high possibility that I will not get any evidence. I did not do a genital examination because I was very clear in my history. I said, did he touch your clothes? Did he take off your clothes? Did he take off your pants? He said, no. He was very clear. So I wrote in the medical documents, and in that they ask you what all you have collected. And in my examination, I said, this is the history narrated by the child, and therefore genital examination was not done and clothes were not collected. Because tomorrow when I go to court, they will say, you did not collect the clothes. You did not collect the genital examination. That means you are in cahoots with the parents to put a false case on the accused. Please realize this happens all the time, right? As doctors, how many of you have been to court, by the way, doctors? How many of you have been to court? None of you? Okay, okay. Was it a great experience? The first time I went to court was in 1999, and my friend who's a high court lawyer, I asked her, what do I do? I was so scared. But she said, no, just go there and speak the truth. He'll ask you this, and you tell them this. Don't make stories, okay? You doctors keep talking too much. So you just say, yes, no, this is what I found, this is what I did. So I was very happy. I went. The public prosecutor asked me questions. I answered very well. I felt so excited. Then the defense lawyer came and said, so how much did they pay you? I'm like, huh? This was not part of the syllabus. I was like, and you know, the previous day the parents had come because this was 5 years after that case. I had seen the case in 95, and in 99 I was called to court. So the parents had come and said, ma'am, that case is coming, will you come to court? And I had got permission from the superintendent to go. And they said, can we give you money for the auto and all? And I said, no, that's not necessary, I will come. So I had come. So I thought they were asking about auto fare. I said, no, I didn't take auto fare. And the defense lawyer, don't talk nonsense, madam. See, she has taken money. And I was like, I kept looking at the guy. He says, how much money have you taken? How have you taken for this false case and all that? And I'm looking at the judge, and the judge is looking over my head at some distant view. I'm like, what do I do? And then I realized that's why doctors are so scared. When I ask them, they say, when we go there, we have character assassination. There was a very high-profile case I was involved in, where I was one of the main people who had found out that the child had been sexually assaulted by her father, sodomized from the age of 2.5. The medical report showed that her anus was the size of a person who is regularly having anal sex, a 3.5-year-old child. That document was never brought into the case. But I had been working in St. John's for 20 years, and in 20 years, every patient who had died in my unit, they brought it all up. I'm like, I saw this case 6 months ago. This is now Pocso had started 6 months ago. The defense attorney, this patient died in your thing. I said, yeah, she came. She was a very serious patient from Dharmapuri who had come, and she had come with this case. So you are doing all these things. I'm like, huh? A case was put. I said, yeah, case was put on the hospital because the family had put a case against the hospital saying the emergency care had not been taken and the patient died. And since I was the doctor under whose unit it was, my name was also in that. So every single case in the hospital of anything, of medical neglect, of death of a patient, anywhere where the family had put a name, every single case I was asked on. I was interrogated for 3 hours, and the next day they called me again for another 3 hours for something which had nothing to do with the sexual assault. And so if the judges don't stop this questioning, doctors will not come. They will not come. Every doctor is like, oh, child sexual assault case has come. It's 3:30. I'm getting off duty at 4 o'clock. I'm going to run and let somebody else take it. And this is a system which I think needs a lot of working out. Let's look at Ravi's story. Ravi is 6 years old, in class 1. His parents are both civil engineers. His mother stopped working after he was born to take care of him. But his father lost his job during COVID, and they are facing severe financial issues, managing on loans from the extended family who live nearby. His father gets angry easily and his parents fight a lot, and Ravi has started going to his uncle's house in the next road after school to avoid the scenes at home. His uncle would spend time with him, give him sweets, admire his teacher's star performance remarks. Ravi enjoyed being there and playing with his cousins. Over the last month, his uncle started calling him into his bedroom and making him sit on his lap. Then he would take off his pants and make Ravi touch his genitals. Now he is making him do things which is painful and scary for Ravi. When he leaves the house, his uncle smiles, gives him sweets and says, "See you tomorrow, okay?" And Ravi nods and leaves for his home. This is called grooming. Grooming is where the perpetrator knows his child is vulnerable because the parents are in a financial. This uncle had been giving money to his brother, who was the father of this child, to help support them. In this case, who's going to complain? How will this child come into your system? Because when these child come in, they're going to keep quiet. This is the large majority of cases. For every 100 children who are abused, only 12 will speak to somebody. That is a friend or someone. Out of those, only 3 will come to a police station or to a doctor. And out of that 3, as we heard, the conviction rate is 12 to 14%. So the fear of being disbelieved. The child feels, this is my uncle. And one of the things I wanted to talk to you about is good touch and bad touch. Don't get confused. There is no good touch and bad touch anymore. We call it safe and unsafe touch. Because if it's a good touch, my uncle is a very good person. He gives money to my parents. He's so good. But he does some things which make me feel very bad. Now I'm confused. Is he good or bad? But everybody says he's good. So must be I'm bad. And once a child starts that cycle, I think somebody mentioned in the morning, I think Kizo had said that the child then ends up with a lifetime of trauma and pain. Because now I know I'm bad, I am a bad person, so what happens? My grades in school start falling. I go to school and I don't feel like talking or taking part in class because I'm this bad person which horrible things are happening to, and I can't tell anyone. And then in a couple of years, one of my friends says, "Would you like to have a cigarette?" And I'm like, I'm a bad person anyway, no? So I'll have a cigarette. Oh, he's giving me weed also. I'm a bad person, right? So let me take weed. And then I'm going down a slippery slope. So when we talk to children, we tell them, if someone touches you in a way you don't like, it's their fault, never yours. And now we call it safe and unsafe touch. Safe touch, my grandmother hugs me, my father kisses me, my mother gives me a hug or puts her arm around me when we sleep. My cousins, we all sit together and we laugh and giggle and all. I feel safe. Uncle who comes and makes me sit on his lap, not safe. My teacher pulling my ear like this, definitely not safe. The school boys in my class who come into the bathrooms and try to trouble me, not safe. Not safe, I'm not at fault. It's somebody else. So for children, they feel they will be blamed. When a child comes home, when your child comes home from school and says, "I failed," or "My teacher scolded me," what do you say? What will you say? What did you do? We first blame the child. So they're so used to it. Now if I tell them sexually assaulted or something, they're definitely going to tell me, "What did you do?" And I don't know what I did, so I'm not going to speak. They fear breaking up the family and fear threats by the abuser. In this case, the child kept on doing this till he was 16 years old. This child actually reported bleeding while passing motion. And he was taken umpteen times to doctors who never asked him even once, "Is someone touching you in a way you don't like?" They kept saying, "Oh, you must drink more water. You're constipated. He's got piles." A high index of suspicion from doctors is very, very important if a child comes with recurrent complaints. And the child is confused and ignorant. I don't know what sex is. I don't know what this is. I don't know why he's doing this stuff. I have no idea. Where will this child meet the system? In this case, the child didn't meet the system. They were adults. He was abused by this uncle from the age of 6 to 16. And finally, I think the father died or something, and the mother went back to her maternal home. And that's when the child spoke about what had been happening to him all these years. So again, the child meets the system through the family members, village councils. These are the people we have to speak to say, if a child is behaving abnormally, whether it's drugs or whether it's abuse, find out, take the child to somebody. This child may come to a government health center, in this case to private doctors who kept treating the child for constipation, for bleeding rectum, never noticing that the uncle was sodomizing the child. Or a psychologist, behavioral issues. You know, my son is so rude, he throws things, he gets angry. for little things, he smashes up things, he keeps hitting his younger brother. So I take him to a psychologist, and the psychologist tells me that the child is being abused in school by his teacher, and he doesn't know how to express it, so he takes his anger out on my glass dishes. To a police station, to a private lawyer, or sometimes a school headmaster. So these are the places we need to talk about child sexual abuse in schools, in hospitals, for psychologists, and in the village community centers. In Bangalore, the police have got what is called Crime Prevention Week in December, because that's the time when the exams are over and they're mainly annual day functions and, you know, sports day and all. They go to all the classes, and from class 6 onwards, the police come, and sometimes they take some people from other NGOs, for child rights NGOs, and they talk about Pocso, they talk about sexual assault, they talk about whom they can come to talk to, they talk about the systems that are available to protect children. And it is for 2 reasons. One, to tell a boy that if you run away with a girl under 18, you will end up caught. And the other, please keep your love for a little longer till she becomes 18. And otherwise, to tell children that if somebody is doing something which is uncomfortable, tell somebody, call Childline. In this case again, with Ravi, when he finally spoke about it, it was reported, there was an interview, but there was no filing of FIR because the parents shut it down. There was no medical examination, no procedure, nothing happened for this child, which is almost 88% of all children who are abused. So, how do we interview a child who has been assaulted? I normally use some pictures because it's very difficult. First, we take consent. Who gives consent for a child to be interviewed and examined? Who will give consent? Sorry? Parents. So the parents or the guardian will give consent if the child is under 12 years. If a child is over 12 years of age, they will give consent for themselves for any non-invasive procedure. For medical examination, for an interview, the child gives consent for themselves if they are over 12 years of age. If you have to do some suturing or you have to do an MTP on the child, then the guardian's signature is important, otherwise not. If the child is a found child, you found the child at a bus stop, the child seems to have been molested or beaten up, physically abused, you will take the child to the hospital. The police person cannot give consent. Even the NGO going with the child cannot give consent for examination. If the doctor feels examination is needed, but there is nobody from the child's family, the child is a found child, 2 options are there. In your hospital, you have to have a committee, which will be your medical superintendent, an RMO or a CMO, who will give consent for the child, saying this child needs medical care and examination, so it may be given. If the child refuses, what do? Doctors? The child says, no, I don't want examination. What will you do? Doctors? Police, lawyers, what can the doctor do? Child says, no, you can't do anything. I'm 14 years old. The child is 14, found somewhere. This is a girl you found somewhere on the road. Someone reported this girl was saying, you brought her to the hospital. Police have brought her. And she says, no, I don't want a medical examination. What will you do? Hello? You have to be examined, otherwise he'll put you in jail. Can I do that? What is wrong with you? Don't you understand? There must be some problem with you. We have to examine you. Will that work? You take informed refusal. Along in the consent form, there is something called informed refusal. The child's right to participate in any activity. So you will tell the child, and so far till today, every child who has come to me has agreed for examination, including a child who ran away and was found to be pregnant. She came, I said, listen, you're in class 9. If you're pregnant, you don't want to have this baby. Do you think the boy will take, he will love me forever. I said, can he look after you? He's in class 11. She said, no. So I said, if I examine you, she said, if you examine me, he will go to jail. So I said, there are ways we can avoid it. When you go to the judge, you will tell the judge that he knew about it and he's going, and he was also 17, so he's going to the JJB. It's unfortunate, but when you go to the judge, you can ask. And I also told the parents about section 482 and said, you will have to, but do you want a pregnancy in the middle of this? Do you think your studies will get disrupted? So finally she agreed for a medical examination. She was pregnant, she underwent an MTP, and the boy came out after 2 years, continued studies, and they came and met me 7 years afterwards, where she had finished her BA and she was working and they were planning to get married. This is one lucky story. There are not so many like that, but it is possible to talk. But if she had refused, there is no way as a doctor I can ever examine a patient against their wish. That is sexual assault. Section 41 notwithstanding. You cannot examine any patient, even a child, without their consent. So under 12 years, parents or guardians have to give. Over 12 years, the child will give their consent. And if it's an invasive procedure for MTP or a surgery, then the guardian has to be given. Now, if this child is 16 years old, she is an abandoned child, she is pregnant, she will go into the state home, and the superintendent or the CWC will give me permission to do an MTP on her or do a medical examination with her full consent. If she says, no, I want to continue this pregnancy, nobody in the world can terminate. So the interview format that we have for the children, I'm not going to go in it because your lunch is getting delayed, so I will just quickly run through. Introduction and consent, rapport building, information gathering either from the attender, the parent who's brought the child's history. Do the medical examination, very, very important to debrief. So debrief the child. The first thing the parents and the child want to know, am I okay? And you say, you know what, with this Lily child, what they did, they told the parents, she's fine, she's got a little tears in the vagina, but she will heal, we will give medicines, and she will be fine. In the girl who was pregnant and went for termination, you will go back to school, you will go back to college, you can continue your life, you can get married later on. Nobody will ever know this happened to you. That reassurance is very, very important. And of course you give it. So I'm not going to go through these because these are things that we would like to do. This is what I follow in these cases. That is the guidelines and protocol, medico-legal. That's what's here. Please read the forms. They are wonderful. They are available online. It's called the guidelines and protocols. So the medico-legal care. This is the MOHFW guidelines. It looks scary, but you will find it's excellent. Plus in the last, there is age estimation and there is what are you sending for FSL. And at the bottom, there is one thing very important written. A copy of this medical report has to be given to the child's family. As soon as it's written, you have to give it. We don't give it, right? We say, no, police will take it. Give it to the police. Police will take it. So you're taking a medical report of the child's assault, and this will be filed in the charge sheet, so it will be given to the accused lawyer, and the defense lawyer will be able to look through this whole thing and take out 500 points to refute it, but you're not giving this report to the child's family. Why? You hate the child so much? You have to give one copy to the child, and you have to give one copy to the police. One copy goes to FSL, because for them, if they know the entire history and the details of the examination, it's easier for them to give a correct report. Like in one case, like at the last page, there is something called, what have you sent to FSL? The child had been assaulted, the chaddi was sent for FSL. So they had written on that for examination for semen. There was also blood stains on the chaddi. But since they did not mention kindly assess the blood group of this or examination of the blood stain, the FSL did not do it. When they asked why didn't you do it, they said you didn't ask us. Please do a complete assessment. It is the IO's job also to check all the evidence collected by the doctor and see that it is all noted down in this, so that whatever has to be seen can be done. It will prevent FSL reports coming back negative. I use these pictures for children when they are less than 9 years of age. Is this you? Or is this you? So the girl will say, no, this is me, okay. And the perpetrator, the person who did this to you, was it like this or was it like this? Oh, like this, okay. Then what did you do? What, can you tell me what he did? She says, yes. I'm not sure, yeah. I said, can you tell me on this picture what he used to touch you? She said, he used this part, he used this part, and he used this part to touch me over here. And so these are anatomic diagrams, and they are admissible in court. I have given these reports many times. I write the FIR number, the name, and I say, These are the places where the child was told. She's 6, 7 years. She has no idea of the parts. She'll say dirty place, susu place, chichi place. She will say flower. She will say something. She will say he did dirty things. In this anatomic diagrams, I know exactly what has happened. She gives me it. I write it down over there and I make a copy and I give this with the report. And I have been cross-examined on this in court also. And I have been able to say, yes, she said these were the parts which were touched. It helped in evidence. So in evidence, one is the direct victim's testimony. This is for the police and for the public prosecutors. Eyewitnesses, as we know, very few. But there was a case where the stepfather came back and assaulted his 16-year-old stepdaughter. The mother and daughter were here. He had another family in Kerala. So he came once and assaulted the child. And when he was going out, the neighbor's daughter, who was a good friend of his daughter, had come inside and he tried to catch her because she saw him and started running. And he tried to catch her and he pulled her dress and it tore, but she managed to run away. The mother told the police this and the police never bothered to ask the family next door. In fact, the neighboring lady was very sorry for this lady. She said, yes, we will come and say that he came and he tore her dress. We've kept the dress, it's torn, that he attacked her. The police said, no madam, the phone number that you have given, mobile number is in Kerala only. That means he was not here, it's a false case. So, eyewitnesses, very important. When we talk of circumstantial evidence, it was a secret crime. But if you have 3 people saying this man went inside the house where the child was alone and then came out, and the child says she was assaulted at that time, those 3 eyewitnesses' report is important. Medical, of course, forensic examination, all these things is what you take. Evidence of treatment. When cases of sexual assault which has occurred, like this boy, the boy who was there, he had recurrent bleeding per rectum for years. That is evidence of treatment for something which was sexual assault. A girl who has urine infection, who starts bedwetting, who's gone to a psychologist, the psychologist's report is very, very important because they say the child has become moody, the child is not going to school, the child sits and cries, the child has attempted self-harm. These are all building up evidence towards the fact that the child has been sexually abused. And circumstantial, there are internet chat records, evidence of grooming of child. If the accused has given money, one of the accused, this girl I met, she was 19, 20 when she came to me. She had a very bad infection. And when I treated her twice or thrice, she came back with the same vaginal infection. And I said, I'm so sorry, I'm going to ask you a personal question. If you don't want to answer, you just say pass. And I said, have you been abused by anybody sexually? And she said, yes. Why? I said, because this is constant happening because she keeps cleaning herself. She feels so dirty, she keeps washing herself. Her uncle had assaulted her. She said, when we wanted to put a case, the uncle said, your father has borrowed 1 lakh rupees from me. He doesn't want to return the money. That's why he's told you to put this case against me. But that is the grooming. So please be aware when you take evidence. If they say, accused says, I have lent money to the family, that was his process of grooming. Please let me know whenever you want to shut for lunch and I will stop. How many people's stomach is grumbling? Everyone? All right. Okay, we will stop. So collection of evidence I've already done. We're not going to go into that. So these are the forms here. These are the forms which you use. I'm just showing you what the safe kit looks like. There are 3 sets. There is white, pink, blue, yellow, and it goes 1 to the hospital, 1 to the police, 1 to FSL, 1 to the patient. Always mark, doctors, mark all this on it and tell the policeman, I found scratch marks on the back. I found scratch marks on the head. All this you have to write down. Use sterile gloves, do the labeling. These are the swabs. If the person is an older woman and she has been assaulted, you can take clippings of the hair and from the comb. You can use normal saline to take swabs. You can use a scissors. If she says, I scratched the person, you can take cuttings from the nails and you can put it in. You can take blood tests. Medical certificate, doctors, you need to have a structure. Write all things clearly. Please write 2 identifying marks of the person. Write down the details of everything you've seen. Write a small history that this is what was narrated to me. Because as a doctor, you are an independent witness. That means you don't know the child, you don't know the accused. You're not involved in trying to put one into jail or keep them out of jail. Your evidence has value. Write your impression clearly that she was assaulted, not assaulted. Never say rape has not occurred. Because unless you were standing there when the child and the person were together and you actually saw that nothing occurred, you cannot say it. Rape is a legal term. You cannot even say sexual assault occurred. You will say penetrative, forceful assault has occurred in the vagina, in the anus, or you will say no evidence of physical or genital injury seen. And the assault may have occurred 2-3 months ago. And when you write that, you will just say sexual assault cannot be ruled out. We know that more than 36 to 40% of actual rape cases have no evidence. Some of the girls, 15, 16, 17, may already be sexually active. You will not get tears, but they have been assaulted. So you will just write physical injury seen, yes, no. Genital injury seen, yes, no. Swab taken, yes, no. Clothes collected, yes, no. For everything, give a reason why. Clothes not collected because this occurred 2 months ago, and therefore the clothes she was worn at that time is not available. She was assaulted 1 week ago, therefore no evidence is collected, no swabs are collected. Write it down, because when you go to court, you will be asked, you may not even remember when this case was. Document everything. And then, copy of the certificate must be given to the child and the family. And you must give the provisional certificate within 24 hours. You can say awaiting for FSL reports, but don't wait longer than that. It drives the police crazy. Okay, clear? I think I'm going to shut off here. There's just one more case I want to bring in. So this is the last story. I will take 5 minutes more. I'm lying, I'll take 7 minutes more. Rita was studying in class 12. After the board exams, the class had a party in one of the students' homes when the parents were out. Alcohol was served and some of the boys had brought weed. After the party, Rita and the classmates she liked went to sleep in one of the rooms. They were drunk and high and ended up having sex. In the morning, the boy apologized and left. Rita has missed 2 periods, is having nausea and giddiness. Now her parents have brought her to the hospital. This child has now come to the government health center, the private doctor, pregnancy test done, and she is pregnant. Now, how will you proceed? Reporting, interview, filing of FIR, medical exam, medical procedure. What will you do? Will you do all this, doctors? Will you do this? You will not, because Justice Chandrachud has given Civil Appeal number 5802 of 2022. I will read it out to you. When a minor approaches a registered medical practitioner for a medical termination of pregnancy arising out of consensual sexual activity, the RMP is obliged under Section 19(1) of the Pocso Act to provide information pertaining to the offence committed to the police. The adolescent and her guardian may be wary of the mandatory reporting, and they have only 2 options. One is go to the RMP and get involved in criminal proceedings, or approach an unqualified doctor for medical termination of the pregnancy, or continue the pregnancy. Both are very harmful for her life. So paragraph 81 says, to ensure that the benefit of Rule 3B of the MTP Act is extended to all women under 18 years of age who engage in consensual sexual activity, it is necessary to harmoniously read both the Pocso Act and the MTP Act. For the limited purposes of providing medical termination of pregnancy in terms of the MTP Act, we clarify that the RMP, only on request of the minor and the guardian of the minor, because here her consent is not sufficient, you need the parents' consent, need not disclose the identity and other personal details of the minor in the information provided under Section 19 of the Pocso Act. The RMP who has provided information under Section 19 of the Pocso Act is also exempt from disclosing the minor's identity in any criminal proceedings which may follow from the RMP's report. This interpretation will prevent any conflict between the statutory obligation of the RMP to mandatorily report the offence under Pocso and the right of privacy and reproductive autonomy of the minor. And so therefore, if they specifically say it is consensual sexual activity, she is within 20 weeks of gestation, and she is willing to undergo, she's consenting for MTP, and her family is there to support her and give consent, you will do an MTP and you only will inform the police station that so-and-so child, 16 years, has come, reported consensual sexual activity, she is pregnant and I am doing a MTP for her. there is no necessity to do anything else. And this has come about because a lot of girls are getting pregnant and continuing pregnancy. Teenage pregnancies, they're scared to come, they die. I have visited 32 homes of women who have died during pregnancy in Meghalaya over the last 1 or 2 years. And 10% of them were teenage pregnancies who denied they were pregnant till the 7th month. It was consensual sexual activity, not rape or assault. And finally, when we got to meet them, the hemoglobin was 5 grams, the blood pressure was 160/100. They all died because they were too scared to come. In no way should Pocso cause the death of a teenager. And so therefore, this is the Justice Chandrachud judgment which is clearly given. Please follow this, doctors. I think I'm going to stop over here. This is the last part. There's a lot more which I would like to talk about. I cannot believe I traveled 9 hours by bus for a 1-hour session, but it seems that's my life. Thank you so much. Any questions, let me know.
Yes, I've been asked to share a few thoughts, but I must express extreme appreciation to Dr. SHAIBYA. We are not very sensitized to the broader aspects of our functioning. And now I am made to recall my interaction with Arjongba when he dropped in over, for a brief discussion over this program that he was contemplating. And we were discussing about a case in a district court where one of the doctors who was asked to examine a dead body could express inability, saying that he is not a forensic expert. Eventually that case could not stand and the accused had to be set free, despite the knowledge that he was the accused, that he had committed the crime. And so we were just discussing, how does a doctor say that he is not able to examine a dead body and give his opinion as an expert? For example, I as a layman, if I am asked to have a look at a dead body, I would have an inspection and find out whether it is a blunt weapon, whether it is a sharp weapon, what is the width of the incision, how deep did it go, or are there any physical marks that indicate bruise, swelling, or any fracture. These are not extremely difficult things, and it is not becoming of a medical doctor to say, I am not a forensic expert. That is not to judge him here now. But I think it is amply clear that there are so many sensitivities, and now the clarification that you need to read together the MTP along with the Pocso Act. I mean, there are so many things now, as she has clarified, even about touching, what is comfortable, what is safe, and what is not safe. And as professionals dealing with human lives, it becomes imperative for all of us to exercise extreme diligence, to take the trouble to update yourself with the latest laws in the country. The latest laws, the latest judgments, they give boost to your case. They seal your case, and they ensure that you handle situations, however diverse it may be, in the most appropriate and legally correct way. So I want to especially request the doctors who are from my department to take the time to read up, to be very, as our speaker has mentioned, to have a very high level of suspicion and not to look at things casually and dismissively, because naturally it is instinctive and it's human nature to try and cloak negative experiences in some other form, as she has shared, of somebody facing abuse at school and then showing out, venting it off differently at home. Trauma is always, it's a human way of dealing with trauma. We try and internalize it, we try and hide it, but then these are experiences that you can never fully erase from your subconscious, no matter how hard you try. And so it will always come out in one form or another. It can even be the loss of self-worth, self-esteem, as our resource person has experienced. And generally you will see that people with low self-esteem tend to have more compromising and permissive behavior. So definitely the manner in which, right down to the manner in which we bring up our children. And I think our society here is gradually moving away from punishing our children physically. In fact, to an extent where many parents are becoming too permissive. And I have been the neighbor of a young man whose tantrums used to last for 1-2 hours. And he used to bang the whole house. And we used to lie down in our bed, wondering what is happening. And this young man running up and down the house, shouting and screaming. That was about 10-11 years ago, when I was in a rented house. It is an amazing sight that you allow one of your children to take your entire house captive. And you come to a point where you as parents are afraid to raise your voice, and you wait for that temper and tantrum to wear out by itself. So there are so many finer aspects, finer things in life, in professions that need to be understood. I hope, and for me, even though I'm not a professional, it is an eye-opening experience and a great learning experience for me. And I will like to encourage all of you that in the work that you do, the duties that you perform, you search and look out for every possible thing that is related to your work, to update yourself, to arm yourself with more knowledge, so that you can be more relevant and you can be more effective in the duties you perform. So thank you, Doctor, for your very incisive sharing. These are all born out of practical experience and a great commitment to work, passion. Things like this flow out from the passion that people have for certain things, and this cannot come out just from intellectual, experience. So with that passion she has, she is now a resource person of great value to so many people like us. We hope we'll interact with you again. Thank you.
Yes, if any question? Or else we have to
So I
proceed.
think Sir was saying, is there any question? And I thought the one question you're going to ask is, when do we run for lunch? I also offer, if you would like, to have an online session later, maybe in the next few weeks, as a follow-up. So for the police separately, for the doctors separately, for public prosecutors, we could have just a 1-hour session, plan it online, and just all the questions you have. Probably with these discussions we've had since morning, you will have a lot more questions also. We can answer them at leisure on an online, or I can request them to send me the typed up questions and I can send the answers to you. Thank you.
Then if there is no question, kindly proceed to dining hall and try to come back by 2:30. Please proceed to dining hall.